us again today.
Thank you so much, Jim. It's really an honor and a privilege to be able to speak to the Supreme Court Historical Society. I'm a longtime attendee at these events, so it's nice to be able to talk about my work with this audience and have this wonderful opportunity. So as Jim mentioned, I've been working for some time. I keep getting interrupted by other projects on a passion project. I like the way you described that, Jim, on the case of ex parte Endo, but more importantly, the people behind the case. This is the case, as I will explain, that closed the Japanese American mass incarceration camps during World War II. So it is a very, very important case. And yet most law students don't study it. Most Americans don't know the story. And I hope very much to change that. As I've told many people, I think Mitsuye Endo should be a household name. She isn't, but she should be. And so if I can do my small part to try and help that along, I feel very privileged to be able to do that. Now, of course, the story of the mass detention of Japanese Americans during World War II in this country starts in December of 1941 with the bombing of Pearl Harbor. And with the bombing of Pearl Harbor, the United States was ushered into war. Congress declared war on Japan the next day and Germany 3 days later. In the hours following the bombing, suspension and martial law was declared in Hawaii. That is to say, habeas corpus was suspended, and I'll talk more about what that means, and martial law was declared in the Hawaiian Territory. This was the result of a proclamation by the territorial governor under powers granted to him by the Hawaii Organic Act of 1900. But meanwhile, on the mainland U.S., there was never any suspension of habeas corpus. And that is a very important precursor to understanding all that followed. Instead, under a presidential proclamation, the military imposed curfews, designated huge portions of the Western United States to be military areas of exclusion, and ultimately created what the military called relocation centers across the West. All of these regulations were aimed at controlling the movements and eventually detaining some 120,000 persons of Japanese ancestry. Among that group were 70,000 Americans born on American soil. Now, it's worth noting also at the outset that that number, that percentage of the 120,000 would have been much higher because many of those swept up in the detention camps were people like Endo's parents who had been in the United States for decades. But at the time, the naturalization laws did not allow immigrants from Asian countries to become citizens. So as I mentioned in the response to Pearl Harbor was immediate and swift. Among other things, within 24 hours of the bombing of Pearl Harbor, President Roosevelt designated Japanese, German, and Italian citizens inside the United States to be alien enemies and ordered those who were deemed dangerous to the public peace or safety of the United States to be subjected to summary apprehension. In the days that followed, the government arrested hundreds and ultimately thousands of aliens. It is worth noting that before all of this, many government reports had cited the Japanese American community as posing a very low risk in the event of war. Indeed, one November 1941 report, a report issued 1 month before Pearl Harbor that had been submitted to the President and the Secretary of War, reported that Japanese Americans in fact posed inhibited an extraordinary degree of loyalty to the United States. The basis for that report was longtime surveillance of the community by the FBI and naval intelligence. Nonetheless, in the weeks and months that followed, President Roosevelt in February of 1942 issued Executive Order 9066. Now, that order authorized the Secretary of War to designate military zones from which any or all persons may be excluded, and provided for the regulation of the terms on which persons could enter, remain in, or be forced to leave such zones. 9066 itself included no language specifically targeting a particular race or ethnicity or ancestry, and it did not specifically by its terms mention detention. Nonetheless, The regulations came to be targeted exclusively at persons of Japanese ancestry and ultimately led to the mass detention of, as I mentioned, 120,000 Japanese Americans. Now, a key player out on the West Coast, where I'm speaking to you from, was General John DeWitt, commanding general of the Western Defense Command. He had pushed hard for expansive powers and eventually the authority to remove and detain all Japanese Americans, claiming that there were many threats posed by the Japanese American community to the United States military interests. All the same, as DeWitt was pushing for these aggressive powers, he received pushback from various persons in Washington. So, for example, in a meeting in February 1942 between War Department and Justice Department officials, the Justice Department proposed a joint department statement. This is the same month that 9066 was issued by the president. A statement that said the present military situation does not at this time require the removal of American citizens of the Japanese race. The FBI, for its part, had found, along with the FCC, no evidence that Japanese Americans on the West Coast were sending signals through lights and radio to Japanese stationed off the West Coast, and reported that the most concerning Japanese Americans were already in custody. 2 days before the issuance of 9066, Attorney General Francis Biddle wrote to the president and said, in referring to newspaper columnists who were calling for the mass detention of Japanese Americans, either they have information which the War Department and the FBI apparently do not have, or they are acting with dangerous irresponsibility. According to Biddle, moreover, FBI Director J. Edgar Hoover held the view that the push for internment was based primarily upon public and political pressure rather than on factual data. This is Hoover, not someone who was sheepish, shall we say, about pushing the boundaries in exercising government authority. Now, it is also the case that key government officials recognized that there were serious constitutional issues and constitutional problems with mass detention of Japanese Americans. So, for example, writing to Congress, Attorney General Biddle wrote, "Unless the writ of habeas corpus is suspended, I do not know any way in which Japanese born in this country, and therefore American citizens, could be interned." Now, here it's worth pausing to explain what Biddle is saying. The suspension clause in the U.S. Constitution, otherwise known as the habeas clause, promises the constitutional writ of habeas corpus. That privilege had been understood at the founding to preclude the detention of persons who could claim the protection of domestic laws, unquestionably citizens, without a criminal trial and conviction, unless the privilege of the writ of habeas corpus was validly suspended. Now, as I mentioned, there never was a suspension on the American mainland. And Francis Biddle, the son of a law professor and someone who knew a lot about constitutional law, immediately flagged this as a problem. As he said, the detention of Japanese American citizens would clearly violate the suspension clause. And I believe a lot of history and case law support that position and that assessment. Biddle also held the line initially in meetings with War Department officials and informed the president in the lead up to 9066 that American-born Japanese, being citizens, cannot be apprehended or treated like alien enemies. Similarly, the Secretary of War, Henry Stenson, like Biddle, a Harvard-trained lawyer, also saw constitutional problems, recording in his diary in February 1942, "We cannot discriminate among our citizens on the ground of racial origins. Doing so by ordering Japanese American citizens evacuated from the Western states," he said, "will make a tremendous hole in our constitutional system." But in the end, these considerations and reasons for pause did not have any effect. They did not matter because effectively Stimson and Biddle folded under pressure and allowed or supported FDR in issuing 9066. The approach that was ultimately adopted, under which FDR gave, in the words of one senior War Department official, carte blanche, is best summarized by a statement of that same official in a heated meeting between War Department and Justice Department officials. Assistant Secretary of War John J. McCloy said to his Department of Justice counterparts, if it is a question of safety of this country, the Constitution of the United States, why the Constitution is just a scrap of paper to me. And so mass evacuation and detention followed. This is where my interest picks up with the case of ex parte Endo, and specifically the principles behind that case. This is a case that was argued before the court on the very same day as Korematsu, and it was decided by this court on the very same day as Korematsu in December of 1944. So we've just celebrated the 80th anniversary of the case. And it is in January of 1945, exactly 80 years ago, that the detention camps began to close. Now, as I've said, Mitsuye Endo is not a household name, but I really believe she should be. I think schools should be named for her. I think she should be on a stamp. She was born in Sacramento. She grew up in Japantown, a vibrant community in downtown Sacramento, and graduated from Sacramento Senior High School. She worked for the state in the California Department of Motor Vehicles. She liked to say that those were some of the best jobs you could get, that is, working for the state outside of working within the Japanese American community. Nonetheless, in the wake of Pearl Harbor, all Japanese American employees of the state of California were suspended on the asserted basis, the state claimed in a letter, that their loyalty could not be trusted. Soon thereafter, the state ultimately fired all of them. Meanwhile, in Endo's case, she had a brother who was serving in the United States Army. He had been drafted in January 1941, months before Pearl Harbor, and served in military intelligence. Indeed, by the end of the war, he had earned numerous commendations, including a Bronze Star. Like many in her community, well, really everyone in her community, Endo and the rest of her family, her sisters and her parents, were ordered to take only what they could carry and leave their home, leave their lives, leave their jobs, and report to an assembly center. They did this, and then shortly thereafter, they were transferred to Tule Lake, a detention camp way up in the most northern parts of California. Now, eventually, they were transferred to Topaz Camp in the Sevier Desert in Utah when the government instituted its loyalty questionnaire of Japanese Americans in the camps and decided to segregate all those who were deemed disloyal and put them at Tule Lake. Meanwhile, a lawyer named Jim Purcell, who was a Stanford-educated San Francisco Irish Catholic lawyer, had been brought in by his friend, Saburo Kido, president of the Japanese American Citizens League, to represent the fired state employees. In the time that he had agreed, when no other lawyer would, to take on this representation, he had occasion to visit other Japanese Americans who were at the assembly center that had been quickly put together at Tamfram Horse Racetrack in Northern California. Now, Jim Purcell was the son of a prison guard. He had grown up on the grounds of Folsom Prison near Sacramento. And so he knew a lot about prisons. And when he went to Tamfram and he saw that the Army had put Japanese American families in horse stalls to live without fully cleaning out the horse stalls, as he wrote, they had simply whitewashed the walls over patches of manure. He said, this is wrong. And he decided then and there that instead of simply challenging the firing of the California state employees, he should challenge something much bigger, namely the detention of Japanese Americans. Now, his inner compass was surely informed by the way that he had been raised. As I mentioned, he grew up on the grounds of Folsom Prison. His father had been a guard and had refused ever to beat prisoners, despite sometimes being ordered to do so. And when prisoners were put in solitary, they were not given any food. In those cases, if his father was assigned to guard them, he would go in to work with not just the one sandwich for himself for lunch. He would always bring a second sandwich to give a prisoner who was otherwise not being fed. Those are the kinds of morals and the example that Purcell had grown up with. And so he, among other things, often told his children over the dinner table, quoting Edmund Burke, the only thing necessary for evil to triumph is for good people to do nothing. And so James Purcell decided to do something. He created a survey that he sent to all the fired California employees, asking about their backgrounds and their families. And through that survey, he picked Mitsuye Endo to be, as he later called her, the ideal candidate, the ideal client. And he was so right about that. He picked her in part because she was a Christian, she had never been to Japan, and her brother was in the army. She was 22 years old in June of 1942 when she authorized him, after some hesitation, to move forward in filing a habeas petition on her behalf in federal district court. She later said, "I was very young and I was very shy, so it was awfully hard to have this thing happen to me. I said, well, can't you have someone else do it first? It was awfully hard for me, but I agreed to do it at the moment because they said it's for the good of everybody. And so I said, well, if that's it, I'll go ahead and do it." Meanwhile, at Tule Lake, she became a full participant in putting together the habeas petition. She sent correspondence to Purcell detailing the conditions and restrictions on those who were being held there. And she also listed the number of guards and what they had done. Interestingly, also at Tule Lake, while she's working feverishly with Purcell to prepare her case, she meets the man who would become her husband, Kenneth Tsutsumi, before he himself secures release and goes to Chicago, where he waits 2 years until he is finally reunited with Mitsuye. In the district court where this case began, there were many theatrics. The case was viewed by many in the San Francisco legal community as frivolous. And indeed, I should say, Purcell and his family received threats and were shunned by many in their community. But Purcell was bound and determined, and the case was anything but frivolous. He presented his preliminary argument at a motions hearing before the district judge, and the district judge, who at the beginning had been among those who viewed the case as frivolous, was suddenly by the afternoon saying, this is actually a very serious matter. After a lunch break, the courtroom, which had heretofore been empty, suddenly was full of military officials. And the district judge reportedly said from the bench at that point, maybe we are in fact impeding the war effort. Meanwhile, in the afternoon arguments, when the government lawyer argued, he maintained that a Japanese invasion was already underway on the West Coast and claimed that the theater of war, and here I'm quoting him, runs from San Francisco to Indianapolis. Meanwhile, as the Endo case is getting started, it had already attracted the interest of key players in the government back in Washington, D.C. And these included all the leading lawyers in the Justice Department. Herbert Wexler, head of the War Department at the Department of Justice, Attorney General Biddle, and the Solicitor General as well. It also attracted the attention of someone who later would sit on the Supreme Court, a man by the name of Earl Warren, who was at the time the Attorney General of California and running for governor. He filed a brief in the Endo case, arguing that California was in effect under martial law, and therefore the military should be, to borrow from John McCloy, given carte blanche to do what it needed to protect the area. This is, I want to flag, a very dramatic argument and not one that was adopted by any court in the case. Meanwhile, Endo was transferred to Topaz. There she was in camp with mostly Northern Californian Japanese Americans. And this group included professors from UC Berkeley, who would have been my colleagues, veterans who had served in World War I, business executives, and families, and many children. Like so many other camps, Topaz had a huge infrastructure that included schools for the children. Life was very hard at Topaz. The camp was in the middle of the Sevier Desert, hours southwest of Salt Lake City, situated in a giant basin with soil that sank and crumbled like chalk when you stepped on it. Families were assigned to single-room barracks with walls composed of tar paper tacked over 2x4s. Black potbelly stoves served as the only source of heat, and privacy was a thing of the past. Bathrooms were communal, as were meals, and the winters were harsh and freezing, while dust storms were common the rest of the year. Windstorms indeed could be blinding, and I know this from having visited where Topaz was located. As Endo later recalled, it felt as if we had dust in our noses, eyes, hair, and mouth for days. Now, the district court ruled against Endo, and the case then went to the Ninth Circuit. The Ninth Circuit sat on the case for quite some time before effectively throwing up its hands, not deciding it, and certifying it to the Supreme Court, in effect, asking the Supreme Court to decide the case for it. Throughout the life cycle of its case, I should mention, Biddle and other senior Justice Department officials talked extensively and repeatedly about the case. And documents that I've found reveal that in 1943 and 1944, they grew increasingly nervous about Endo's case's prospects. So much so that many of the large-scale policies that were put in place by the government during this period were driven by the Endo case. Among other things, the government officials that is, decided to really hone in on this concept of loyalty. And government lawyers began formulating policies to allow detainees to petition for release if they could line up a job or schooling outside the evacuation areas and prove to hearing boards that they were loyal. Going home to California was never allowed, but you could get released to other parts of the country. So, for example, Endo's two sisters won release and went to Chicago. Now, the fact that 85,000 Japanese Americans were still in the camps in December of 1944 does, however, reveal how difficult it could be to secure relocation and release. But by implementing these policies, the lawyers in Washington believed that they could argue to the Supreme Court, if Endo's case ever made it there, that the Japanese Americans in the camps were not being detained against their will, at least those who had been deemed loyal. Also in 1983, I was off by 40 years, 1943, Francis Biddle was going around giving public lectures in which he said that the detention of citizens was unconstitutional. Nonetheless, this was happening at the same time that he was advising his team of lawyers in justice, led by Herbert Wechsler, to fight all the legal challenges being brought in cases like Hirabayashi, Korematsu, Endo, and Yasui. The other thing that the Justice Department lawyers did, Herbert Wechsler, among others, being very well attuned to federal court's jurisprudence, was offer Endo release. They offered her outright release. Well, not outright. It was conditional on not going back to the West Coast. And they knew that if they did that, if she accepted the release, the jurisdiction of the courts over her habeas petition would be extinguished. That is because for a court to have jurisdiction in a habeas corpus case, it has to be able to reach the custodian of the prisoner. And if there's no prisoner, there's no jurisdiction. But Endo turned down release. She did this while Kenneth waited for her in Chicago. She did this while she watched her sisters leave in 1943 to go to Chicago. She was, Purcell had correctly predicted, in fact, the ideal client. She said later, the fact that I wanted to prove that we of Japanese ancestry were not guilty of any crime and that we were loyal American citizens is what kept me from abandoning the suit. Meanwhile, President Roosevelt gave a speech in 1943 about loyalty not being tied to race or creed, as he opened up the military at long last to Japanese Americans who had been deemed ineligible for military service through this whole period since Pearl Harbor. Now, the case, as it makes its way to the Supreme Court, has a connection to Korematsu. As I mentioned, it was argued the same day as Korematsu. It was also decided the same day as Korematsu. And after a large and heated conversation among Justice Department lawyers in the parallel Korematsu case, the lawyers relied on General DeWitt's so-called final report that had claimed many falsehoods about Japanese Americans signaling and doing other things to support the Japanese military from the West Coast. In the Endo case, and this is my read of the government's brief, aware that they did not have winning constitutional arguments, the Justice Department lawyers instead emphasized the process by which detained Japanese Americans could obtain leave passes. Yes, again, the idea was to present these Japanese Americans as staying in the camps voluntarily. Purcell, for his part, relied heavily on the court's Civil War precedent of ex parte Milligan, a case in which the Supreme Court had rebuked President Lincoln's military trials of citizens, as well as his administration's attempt to justify detention of Milligan and others as political prisoners outside the four corners of Congress's declared suspension of habeas during the Civil War. Now, relying on Milligan was important, and relying on the suspension clause arguments was also important for Purcell, because although the military regulations had discriminated based on Japanese ancestry, in 1944, the Supreme Court had yet to recognize an equal protection component barring discrimination by the federal government. It had only done so in the state context. It was not until 1954, in Bowling versus Sharp, some 10 years later, that the Supreme Court finally interpreted the Constitution to ban discrimination by the federal government. So here's where things get even more interesting. As the case is pending before the Supreme Court, several things happen. First, Chief Justice Harlan Fiske Stone holds up the court's opinion, which William O. Douglas had drafted, for several weeks over Douglas's angry objections. Second, Douglas, meanwhile, has his law clerk, the first woman law clerk on the Supreme Court, Lucille Lohman, draft a memo about whether or not this could be the case to announce that equal protection limits what the federal government can do. In other words, we might not have had to wait another 10 years for Bowling versus Sharp if Douglas and other members of the court had adopted that position in the Endo case. And finally, the court's timing of its decision is very curious indeed. The case was handed down on a Monday in December of 1944, but the camps had been announced that they would be closed the afternoon before, a Sunday afternoon press conference and release. The government overnight moved, over Sunday night that is, moved to have the case dismissed as moot. All of this suggests strongly that the White House had been tipped off that it was going to lose the Endo case, which it did. The court nonetheless did hand down its decision, but the court didn't decide any major constitutional law issues. Instead, in the ex parte Endo decision, the court held that the military regulations governing detention and the camps did not permit the continued detention of anyone the government conceded was loyal. In so doing, the court did not define what loyalty was, but it borrowed heavily from Roosevelt's earlier speech in saying loyalty is a matter of the heart and mind, not of race, creed, or color. The real significance of the court's decision, therefore, is not so much in the words that it wrote, but it is in the fact that Endo stayed the course. And we know that Roosevelt had been pressured for some time to close the camps, but it was really only after the election of 1944 and with the knowledge that the Supreme Court would issue a rebuke of what the military was doing, maybe not as broad as Purcell and Endo would have hoped for, but a rebuke all the same, that Roosevelt finally, at long last, the day before the Endo decision came down, agreed that the camps should be closed. For her part, Endo only learned of her victory the next day. When she did, she grabbed a friend from the office where she worked at the Topaz camp and danced around the room. Then she sent a telegram to Purcell telling him, "I'm extremely joyous of results. Appreciate very much your long effort in restoring our rights." It's worth highlighting here that it was her effort too. She doesn't leave the camps until 1945, as the government starts to close them down, and she goes to Chicago. She would not go back to California. She later told her children that she did not feel welcome there anymore. But in Chicago, she reunited with Kenneth Tsutsumi, married him, and had a family. And later, when the law finally allowed it, her parents, who had also come to Chicago, and as I mentioned, had lived in the United States for decades, long before Pearl Harbor, finally became citizens. In the years that followed, Endo, ever humble, rarely spoke of her case and granted few interviews. But in one of the few interviews, looking back on the case some 30 years later, she said, "I showed people what I could do." So why is it important to study this episode? Here, I'll come back and I will quote another member of the Supreme Court, Justice Antonin Scalia, who was good friends with the justice for whom I clerked, Ruth Bader Ginsburg. In a speech in Hawaii in 2014, he said, and I quote, "Of course, Korematsu was wrong, but you are kidding yourself if you think the same thing will not happen again." This is why I think it's so important to study this episode, to learn about this case, to study the court's role in all of these cases from this period, and to have an appreciation for the people behind Endo's case in particular. I want to show a few images, and then I'd be delighted to welcome some Q&A. Now, if I can share my screen here, hopefully you can all see this. Again, this is Biddle's quote, but unless whoops, shoot, now I can't go back. These are the exclusion orders that were put up telling Japanese Americans on the West Coast that they had to leave their homes and report immediately to be sent to assembly centers. This is a grocery store in Oakland, California, just one town over from where I am. This is a store that was owned by a Japanese American man who was a graduate of UC Berkeley, where I teach. And this is his message to his fellow Californians: "I am an American." This is part of the scenes in San Francisco in April of 1942 as Japanese Americans reported to be bused to assembly centers. Similar scenes over on the East Bay in Hayward in May of 1942, a grandfather with his grandchildren. This is the image of Tanforan. These are the horse stalls where James Purcell saw families were being housed that inspired him to do something bigger. This is the Santa Anita Assembly Center being guarded by the military. These are children boarding the train from Tanforan to go to the Topaz camp in Utah. This is the Topaz camp where Mitsuye Endo and her family lived. This is Topaz, the welcoming center. This is Topaz today, to give you a sense of what it looks like. I include the picture in the corner. It's on the location of where a woman who I had the privilege of interviewing lived as a child. I went to the site where her barracks were located. She had told me before my visit that in the desert, they liked to catch scorpions and keep them in jars, and they poked holes, as one does, in the top of the jars to allow air in. And this is the top of one such jar that I found in the exact location where her family's barracks had been. This is Endo working in the administrative building at the Topaz camp. And this is James Purcell. The other thing he liked to say to his children was, "You can change people's hearts and minds. You can't change people's hearts and minds, but you can make them follow the law." This is the telegraph that Endo sent to James Purcell upon hearing of her victory, upon hearing that the Supreme Court had ruled in her favor. And this is Endo leaving Topaz at long last in May of 1945. So thank you so much for your patience and listening. And Jim, I hope we have some questions.
We certainly do, and thank you so much for this wonderful presentation and thorough research that you've done. We're anxiously awaiting your book on this. I had a couple questions, and we have some from the audience as well. but as you were describing Mitsuye's Endo's comments afterwards in her life, are there video interviews of her, or is it?
Not that I have found, but
Yeah,
if anyone watching knows of any, by all means, please tell me.
yeah,
I would really like to see them.
it would be fascinating. You it came back to the point on habeas and the suspension of habeas. Can the president alone suspend habeas corpus? Does it take an act of Congress to ratify it? And it might compare the uh, ex parte Merriman situation with this one.
Yes, I'm really delighted to take this question, having written 2 books on habeas, including one called Habeas Corpus in Wartime, where I walk through a lot of this history. And as you allude to, during the Civil War, and as most people know, President Lincoln suspended habeas ahead of Congress. Now, he did so initially in small batches, and one of those is around Baltimore, and that leads to the case of ex parte Merriman. But eventually, in short order, he declares a nationwide suspension by proclamation. And it's not until 1863, 2 years into the war, that Congress finally passes legislation suspending habeas. And of course, Lincoln immediately again acts on that. So that raises hugely significant questions. If it is the case, and this historically was true, that suspension of habeas allows the government to detain persons without trial, it is a very dramatic power. And indeed, even Lincoln himself recognized that and was very thoughtful about that. He recognized that it was an awesome authority to claim. But Congress wasn't giving him the power, and he wasn't about to wait any longer. He did what he thought he had to do to protect the country. Now, there's a cart and horse problem there in terms of how this actually played out. If he hadn't acted, maybe Congress would have. If he had gone to Congress and asked for it rather than claiming the authority, I think there's a very good chance it would have acted much sooner. So it's hard to know, how the counterfactual would have played out. But all of it led to, as you alluded or mentioned, to the ex parte Merriman decision, a case in which Taney, sitting as circuit justice, rebukes Lincoln and says, no, you don't have this authority, and you can't hold Merriman without trying him. There are so many interesting aspects to this, not the least of which is Lincoln actually wound up letting Merriman go rather than try him. So he didn't openly defy the decision, but he did openly disagree with it. And that is something that Lincoln did with other decisions as well, including Dred Scott, for example. The Taney decision, one always wants to tread lightly in saying Taney was right about really pretty much anything. But he writes a very good decision in Merriman, where he goes through the English legal history that leads to this concept of habeas and this concept of suspension. And he explains that the suspension framework was, and this is correct, the creation of Parliament. And it was all done for the purpose of limiting the king's power to detain individuals without trial. And so he makes a very powerful case, and I will say I've concurred with it in print, that this is a legislative power.
Yeah.
And it's really only where there's complete breakdown of law and order, and we're in a state of martial law, where we don't need a suspension by legislative means for the executive to exercise this power.
Yeah. Great. Thank you for elaborating on that. Another thing you mentioned that I may have missed about Earl Warren's assertion that California was under martial law at the time. That he was not governor at the time, was he?
No,
Or was
he was
he was
running for
running?
governor.
Right.
And this was good politics. He gave a number of speeches about the dangers of the Japanese American community. He filed briefs also in Korematsu and in other cases. He was very active on this front.
Mhm. Mhm.
And unfortunately, I think on the wrong side of history.
Yeah. No. Questions from the audience include why do you think Endo's story is less known than that of Fred Korematsu's? And understand President Biden awarded her the Presidential Citizens Award earlier this month.
Yes, and I meant to mention that, so I appreciate the question. President Biden gave her the Citizens Medal a few weeks ago. It is not on the same level. It's sort of one tier down from the Medal of Freedom. I think that's unfortunate. I think she should have been given the Medal of Freedom. Korematsu, Hirabayashi, and Yasui, the three men who brought their cases to the Supreme Court, they all previously have been given the Presidential Medal of Freedom.
Mm.
I will say, I think part of the problem is the wrong word. Part of the explanation for why maybe she is not as well known, why it has taken so long for her to receive any presidential recognition, is because she was not as much of an activist in later parts of her life. But one shouldn't discount that after leaving the camps, she went to work for the Chicago government on race relations. So she did do a lot of work in this area. She raised her family, but she otherwise was very private about the role that she had played in ex parte endo in this whole period of history, as important as her role was. I think she's the woman who closed the camps. She and her lawyer are the direct link to the closing of the camps. So I think it's probably in part because she was less a public figure later in her life. Korematsu, Hirabayashi, and Yasui were activists, to their great credit. And, everybody knows about Fred Korematsu's story, or they should. And that's wonderful. And so I think that's a big part of it. I do also worry, though, that part of the reason that she and her story are not better known is because she was a woman. She was a woman of color. And we don't have a great track record in this country of always celebrating heroes from the past who fit into those categories. And so, one of many things I hope is that by talking about her, by writing about her, I draw attention to her story so that people can be inspired by it, because she really is quite heroic.
Well, we're very grateful. You're raising her profile, and again, anxiously await your book, and hopefully that will help make her story more well known and appreciated as she should be. Is another question. It seems as if this story was hiding in plain sight. How did you learn of and become interested in pursuing it? And did Endo or any of her relatives receive reparations under the Civil Liberties Act of 1988?
Great questions. Let me start with the latter and then come back to the former.
Sure.
I don't know, but I would assume that reparations were received. As the questioner likely knows, but maybe some others don't, the government did ultimately apologize and pay reparations. I believe it was $20,000, but I'm happy to be corrected in the Q&A. I'm just going from memory, to those who had been in the camps. I don't know for certain if Endo received reparations, but I would guess so. How did I come about this is a really interesting question, because as I've said, law students don't generally, unless they take my classes, learn about ex parte endo.
Yeah.
It wasn't in the main federal courts casebook, which I should mention, I am a co-editor of, and the casebook is called Hart and Wexler's, The Federal Courts and the Federal System. That's the same Herbert Wexler who was running the War Department litigation during World War II at the Justice Department. That casebook did not cover at all the mass incarceration of Japanese Americans until the 8th edition, which came out 2 weeks ago, and of which I'm the editor of the habeas chapter. So now ex parte endo is in there, and discussion of the mass incarceration of Japanese Americans is in there in the discussion of the suspension clause. And I'm very proud of that addition. But it is the case that I didn't know about this case as a student. And I didn't know about this case until I became a law professor and started researching the history of habeas corpus. And even then I didn't know about this case. It's only when I started to write about the English legal history and the founding period, the way suspension worked during the Revolutionary War and then the Civil War, that I started to think, wait a second, the Japanese American incarceration is a blatant, flagrant violation of the suspension clause. And then I started digging into World War II. And that's where I discovered Endo, and some work by other scholars that had, in some cases, gone into great length studying the Supreme Court portion of the case, and in other cases, in passing, discussed her case. But that goes back to the earlier question. There are some very prominent books about this period and the detention camps. Endo is only mentioned in passing, and in one such book, she's referred to as a passive, just nameplate, really, for the
Mm.
case. And that's just simply not accurate. She was very actively involved. She was sending notes to Purcell with details about the camps to help him shape her habeas petition. And she made a very heroic sacrifice to stay at
Stagnant.
Topaz
No.
for 2 years to keep this
Mhm.
case going.
Mhm. Mhm. Yeah, good points. Were the assets and homes of detainees confiscated by the government?
That's a really interesting question. And here I'm going to draw in some comparisons to Canada. In Canada, yes, they were outright claimed by the government. In this country, they weren't, but the Japanese Americans who were ordered to evacuate on the West Coast, they had very little time to make arrangements, at most a week, and they could only take what they could carry. And what that meant is that properties and belongings were sold at fire sales for pennies on the dollar.
Mm.
And where they could, Japanese Americans would arrange with neighbors or friends to watch over their properties. And sometimes people honorably did so, and the Japanese Americans had something to come home to. But sometimes people would agree to do it, and then they would just take the property. And so, for those Japanese Americans who returned to the lives that they had had on the West Coast, for many of them, they had to start from scratch
Mm.
after the war. And it's worth noting here, I mentioned that Endo herself had grown up in Japantown, which had been this vibrant, wonderful community in downtown Sacramento. Shortly after the war, Japantown was ordered razed. And that area became the downtown capital area of Sacramento, where we have the state capitol. And Japantown was effectively wiped off the map. And it's another example, it's a really good analogy to how this history has sometimes been erased. But I think it's really important to, bring it back to the fore and study it.
Were they expected to pay taxes while they were encamped?
I'm making a face because I've never thought about that, and
It just
I don't know.
I don't know.
I
It just occurred to me that insult to injury type of
Well,
inquiry.
you raise a good point, and I don't know that, and I'll have to look into that. But a friend of mine who's actually given lectures for the society, Professor Gerard Maglioka, recently
Yeah.
flagged to my attention that there's a case about a Japanese American man who was drafted, and he was at Tule Lake, and he was drafted, and he responded. He said, "My government has locked me up. You can't
Yeah.
force me to serve in the military of a government that is imprisoning me." And in his case, it was before a district judge who agreed with his argument and said, "No, this violates the Constitution."
Yeah.
But so it is worth noting that there were Japanese Americans who were incarcerated who were being drafted.
Yeah.
Now, most of the 442nd and the decorated units who went to extraordinary lengths in fighting for the United States military are the most decorated veterans of World War II, the
Hmm.
Japanese American units. Most of them volunteered, and they
Yeah.
volunteered, many of them from the camps.
Yeah.
So it is worth highlighting that. I don't want to
Mhm.
just tell a story of resistance. I also want to highlight
Oh yeah. No, there were
and
heroes. I have a relative.
absolutely heroes.
Yeah, I have a relative who's one of them, and a hero in the war and of Japanese American descent. Um, uh, well, this is let's see another observation. This isn't a question, but Mitsuye Endo was inducted into the 18th class of the California Hall of Fame in December of 2024.
Yes.
So another,
Yes, she was. And interestingly, it was an all-woman induction class.
really, yeah.
Yes, and I think that might have been a first for California. But
Uh,
it's really wonderful. I do think that she and her story are picking up some momentum.
yeah.
It's great to see the president recognize her. It's great to see the state of California recognize her.
Well, this has been great. We're so grateful for you both participating. Oh, hold on. We got some more here. I thought we were at the end of the questions. We're not. Um, let's see. Uh, okay. Well, should have raised this one myself too. Justice Rehnquist wrote a book about habeas during wartime. All the Laws But One is the name of it. He attempted to distinguish between detention of aliens or natural-born citizens on the one hand and detention of natural-born citizens on the other. He criticized the latter, but was equivocal on the former. What are your thoughts on his observations in that book?
It's a very good book, and I've relied on it in my work. I think he's right to say that it is not a hard question with respect to natural born citizens.
Yeah,
It's not a hard question that the full Constitution applies. As I've written, the suspension clause seems to me very clearly having been adopted to preclude the government from detaining people without trial in the absence of a valid suspension. And that makes the detention of Japanese American citizens clearly unconstitutional. In other words, Francis Biddle was right about that. I wish he'd held the line more firmly, but he was absolutely right about that. Now, it's a harder question generally with aliens, non-citizens. In English legal tradition, generally speaking, the understanding was if a party had come into the protection of the crown and could claim the protection of domestic law, they could invoke the Habeas Corpus Act. Um, English legal history is a little muddled on what the standard was if England was at war or Britain was at war with the country of origin of the individual. There is a case of a Frenchman who claimed the protections successfully of the Habeas Corpus Act, the English Habeas Corpus Act, during a time of war between England and France. But there is a lot of history on the other side that says no habeas rights. All of this is very complicated in application to Japanese American immigrants, in my view, because they weren't allowed to naturalize. And you take people who've been here for, I think Endo's father had been here for 40 years. He was very much an American. To say that he should be treated as an alien enemy because he was not a citizen when he wasn't allowed to naturalize, it strikes me as problematic.
yeah,
We could talk at some length about this, but at best, I would say it's complicated. Um, I certainly don't think it's clear cut in that case that he has no constitutional rights. That just can't be right.
yeah, yeah. Well, this has been enlightening, and we're very grateful for your work and your efforts on this, and delighted you joined us today on this, Amanda. We're looking forward to when your book is published, and we'll certainly carry it in our gift shop when it is.
Thank you.
And but for anyone who's interested, there are signed copies of your book with Justice Ginsburg called Justice, Thou Shalt Pursue, a life's work fighting for a more perfect union. I believe a copy of it is over your right shoulder. As we view you, you're on the left of that book. And we do carry that in our book store gift shop. And it's available at www.supremecourtgifts.org. And we encourage you to read that one as well. So we have two programs scheduled for February. On February 6th at 7 p.m., Professor Brad Snyder will be joined by Professor Kenneth Mack for a discussion of Brad's new book, You Can't Kill a Man Because of the Books He Reads, Angelo Herndon's Fight for free speech. And on February 24th at noon, Professor William Castro will join us for an in-depth look at the life and career of Chief Justice Oliver Ellsworth. Registration will open on the Society's website at www.supremecourthistory.org next week. And finally, a survey will go out later this afternoon to everyone who registered in advance for this lecture. Please do respond. Next month's program on Chief Justice Ellsworth is a direct result of multiple members asking for content on the Chief Justices. So we pay attention to your responses, and we're grateful for them, and we're grateful for your support. Your feedback is critical in making them as our programs as engaging as possible. And today's certainly ranks very high up there among engaging and interesting topics. And we're so grateful for Professor Tyler's work in this field, and grateful for her friendship with the Society. So thank you for joining us today. And with that, we are adjourned.
Thank you, Jim.
Thank you.